The pen was still in my hand when my brother's wife pulled out her phone. I watched her from across the conference room table, the signed settlement agreement sitting between us like something already buried. She didn't even wait until we were out of the building. She was already typing with both thumbs, that particular speed people use when they're delivering news they've been saving up. My brother Colt leaned back in his chair and let out a long breath through his nose. Not relief exactly. More like a man releasing something he'd been holding so long he'd forgotten it was there. Their attorney, a compact man in a charcoal suit who had said approximately 400 words in 2 hours, was already collecting his papers. I drove home alone. The settlement meant I was walking away from the business my mother had built over 22 years. The one I had spent the last 3 years keeping alive while she was dying. I want you to understand what that means before I explain what I had already done about it. My mother opened Strand & Bauer Interiors in a rented storefront in Decatur, Georgia when I was 4 years old. She built it from a drafting table and a Rolodex into a regional firm that by the time I was in college employed 11 people, maintained accounts with 4 hotel groups, and had completed renovations on 2 municipal buildings. She was not a warm woman in the way people mean when they say that. She was exacting and impatient, and she had opinions about crown molding that she would share whether you asked or not. But she was consistent. She showed up. She kept her word. She kept receipts. My brother is 6 years older than me. He left for the University of Colorado when I was 12, came back for holidays with a series of enthusiasms that changed every 18 months, and eventually settled into a career in commercial real estate that he describes as going really well in a way that has never invited follow-up questions. His wife, who I will call by the name she prefers on her lifestyle blog, Cassidy, has a talent for entering rooms as though she arrived from somewhere better. When my mother was diagnosed with ovarian cancer in the spring of my 31st year, I had been working as a forensic accountant for 7 years. I audit financial records for litigation. I find the numbers that don't add up, and I build the documentation that explains why they don't add up, and I do this with the kind of methodical patience that my college roommate once described as genuinely unsettling. It is not glamorous work. It is the kind of work that requires you to read the same spreadsheet 6 different ways before you're willing to say anything about it out loud. I became my mother's primary caregiver the month she started chemo, not by formal agreement, by the simple mechanics of geography and availability. I lived 40 minutes from her house. Colt and Cassidy lived in Denver. The distance was mentioned in the first week, and then never again, as though its mention had resolved something. What I want to say about those 2 years is that they were the most clarifying experience of my life and also the most exhausting, and those 2 things coexisted without resolving each other. I learned how to read an oncology report. I learned which of my mother's doctors would call me back and which would not. I learned that she took her anti-nausea medication better if it came with a small glass of ginger ale, and that she wanted the television on but not loud while she slept, and that she had opinions about the specific brand of compression socks Medicare would cover that she was not going to soften for anyone. I drove her to 61 appointments. I know because I kept a log. Forensic accountants keep logs. Colt and Cassidy visited 4 times over 22 months. Each visit lasted between 4 and 7 days. Cassidy brought a tote bag of organic snacks that my mother thanked her for and did not eat. Colt sat with her in the evenings and talked about his work and his plans and a development project outside Boulder that was going really well. He was not unkind to her. He was present in the way people are present when they are performing presence rather than practicing it. My mother's business manager, a woman named Yvette who had been with Strand & Bauer for 14 years, called me in the fall of my mother's 2nd treatment year to tell me that 3 vendor accounts had gone unpaid for 90 days and that 2 of the firm's designers were considering other opportunities. My mother had stopped coming in regularly 4 months earlier. I started coming in. I did not have an official title. I did not take a salary. What I did was learn the firm's billing system, stabilize the vendor relationships, sit in on the project reviews Yvette ran, and keep the 11 people employed there from making decisions they would have had to make if the business had visibly started dying. I told myself I was doing it for my mother. I think I was also doing it because it was something I was capable of doing, and in a period of many things I could not fix, having something I could fix felt necessary. My mother updated her estate documents 14 months before she died. I know this because her attorney, a careful and measured man named Mr. Okafor who has been practicing estate law in Atlanta for 30 years, told me so afterward. She divided her personal assets equally between myself and Colt, and she left the business in a structure that gave me controlling operational authority while preserving Colt's equity share. She had done this deliberately. She had also, I would later learn, included language in the trust that I did not know about until it mattered. She died on a Thursday in November. The kind of gray, quiet November day that does not bother to be dramatic about the things that happen in it. I was there. Colt had flown in 4 days earlier and was at the house. We did not say much to each other that afternoon. Some silences are not about people who don't get along. The conversation about the business started 8 days after the funeral. I say started because Colt framed it as a conversation and I took it as one, which was the first mistake. He called me on a Sunday evening and told me he had been doing some thinking. He said the business represented a significant asset in the estate and that he was concerned about my capacity to manage it properly given everything I had been through. He said this with the careful neutrality of someone who has practiced a sentence. He said he and Cassidy had been consulting with a business advisor, not a lawyer, a business advisor, who had looked at the firm's recent numbers and had concerns. I asked what kind of concerns. He said the firm had underperformed for 2 years and that its current valuation reflected that, and that he wasn't sure holding a minority equity stake in an underperforming company was the right position for his family. I said I understood. I did not say that I was the reason it had not underperformed more significantly. I did not say that the numbers he was describing reflected what the firm looked like before I came in, not after. I asked him to send me the advisor's report. He said he would. He did not. Over the following 3 weeks, the calls became a pattern I recognized from professional experience. Each one arrived with new information that built on the last. The business advisor had recommended a valuation that I should review before making any decisions. A buyer had expressed interest, and the window was time-sensitive. There were tax implications to my mother's trust structure that could create personal liability for me if the business wasn't properly restructured. He was only telling me this because he wanted to protect me. He was only pushing because he knew I was tired and he didn't want me to make a decision I would regret. Cassidy sent me a text that said simply, "Thinking of you," which under the circumstances functioned less like comfort and more like a flag. I am a forensic accountant. I spent 7 years finding the financial version of what Colt was doing to me in these phone calls. The architecture of urgency layered over incomplete information, layered over emotional leverage. It is a structure I have seen in fraud cases, in embezzlement investigations, in contested divorce proceedings. I recognized it the way you recognize a street you grew up on even after they've changed all the signage. I called a vet. I pulled the actual financials for the past 36 months and built a real performance analysis. I called Mr. Okafor and had a conversation about my mother's trust language that turned out to be the most important conversation of the previous year. And then I drove to the electronics section of a Target in Midtown and bought a small digital recorder that fit in the inner pocket of the blazer I wear when I want to feel like I know what I'm doing. I called Colt and told him I was ready to discuss the business. I told him I had reviewed the valuation concerns and had questions. I suggested we meet in person. He agreed with an ease that confirmed he believed the conversation was already decided. We met at a restaurant near his hotel. He had chosen it, which I had expected. It was quiet. The tables were spaced. I arrived first and chose a booth in the back and activated the recorder before he sat down. What happened over the next 90 minutes was, professionally speaking, a thorough documentation event. Colt had not brought the advisor's report because there was no advisor's report. What he had was a set of numbers he had pulled from the estate's preliminary inventory and a set of conclusions he had drawn from them without understanding what they represented. When I asked specific questions, the kind of specific questions I ask in depositions, the answers stopped adding up in real time. He told me the firm's largest hotel account had canceled when in fact it had renewed 6 weeks before my mother died. He told me the staff had been reduced to 7 when there were still 11 employed. He described a lien on the business equipment that I knew did not exist because I had verified it with the county recorder that morning. I asked him calmly what he thought I should do. He told me I should sign over my operational authority in exchange for a buyout at the valuation he had described. He named a figure. He said it was fair, given the circumstances. He said Cassidy had found someone who was interested in acquiring the firm and that they could move quickly if I was willing to be reasonable. He used the word reasonable twice. He used the phrase fresh start. He told me, with a particular flavor of brotherly concern, that I had sacrificed enough, and that holding on to the business would just mean continuing to sacrifice, and that our mother would have wanted me to be free of it. Our mother would have wanted no such thing. She had structured the trust specifically to prevent exactly this. I thanked him for his concern. I told him I would think about it. I picked up my water glass and did not let anything show on my face because I have been doing this work for 7 years and the face is part of the work. I met with Mr. Okafor the following morning and sat across from him in his conference room on Peachtree Street and placed the recorder on the table between us. He listened to 40 minutes of the previous evening. When it finished, he was quiet for a moment and then he said, "Well," he said it in the tone of a man who has spent 30 years in estate law and has learned not to be surprised and is surprised anyway. What my mother had included in her trust documents, the language I had not known about until Mr. Bano Okafor told me, was a provision that addressed exactly what Colt had been doing. Any beneficiary who made material misrepresentations in connection with the administration or distribution of the estate, or who attempted to induce another beneficiary to surrender their interests through fraudulent or coercive means, would forfeit their equity share in all business holdings included in the trust. My mother had not been a warm woman, but she had been exacting and she had kept receipts, and apparently she had also expected this. Mr. Okafor filed the documentation that afternoon. The settlement meeting was scheduled 2 weeks later. I sat across from Colton Cassidy and their attorney, who had the professionally neutral expression of a man who has recently learned his client was less forthcoming with him than anticipated. The settlement agreement on the table gave me full operational and equity control of Strand & Bauer Interiors. Colt received a buyout payment calculated on actual valuation. Their attorney had advised accepting it. Colt signed without looking at me. Cassidy looked at her phone. I signed every page clearly with the same pen I use for deposition documents, and I placed the cap back on carefully. I drove home alone. Not in triumph. That is the part of these stories that I think people sometimes misread. What I felt sitting in my car in the parking structure for a few minutes before I started the engine was not satisfaction. It was something closer to the specific exhaustion that follows a very long project when you have finally submitted the final deliverable and the work is done, but the weight of having carried it doesn't lift the moment you put it down. I cried for about 4 minutes. Then I drove home, fed my cat, and sent Yvette a text that said, "It's settled, we're okay," and she replied with a string of exclamation points that I stared at for a while, before setting the phone face down on the counter. The firm is doing well. We brought on a new junior designer in February and renewed the hotel account for another 2 years. I have a proper title now and a salary and a business card that has the word principal on it in a font my mother would have approved of and possibly selected herself. I have not spoken to Colt since the settlement. I blocked both their numbers after the paperwork was filed. I don't know if that was the right decision, and I'm not sure I need it to be. What I want to say, and I mean this not as a moral but as something I think about when I can't sleep, is that the hardest part of what happened was not the legal process or the financial complexity or even the betrayal, though that was significant. The hardest part was the 6-week period before I bought the recorder, when I almost let the exhaustion make my decisions for me. When the urgency he was manufacturing almost succeeded because I was tired enough to want it to be over more than I wanted to be right. Grief makes you porous in ways you don't anticipate. You become temporarily permeable to whatever is being pressed against you, and if what's being pressed against you is a carefully constructed series of pressures designed to look like they're coming from love, the permeability is dangerous. I had the professional training to recognize what was happening. I'm not sure I would have recognized it fast enough if I had been any more depleted than I was. My mother kept every invoice she ever sent. She kept every signed contract, every change order, every client communication worth keeping. Organized in binders she labeled in her particular handwriting with the black fine-tip marker she used for everything. I found 6 boxes of them in her office when I cleaned it out. I kept them all. I don't know exactly why. Maybe because they're evidence of something. A woman who built something from nothing and protected it carefully and trusted someone to receive it. I want to ask you something, and I mean it as a genuine question, not as a way of ending on something that sounds better than I actually feel. If someone you trusted used your exhaustion as a tool against you, not cruelty exactly, not violence, but the quiet exploitation of the moment when you were most depleted, how long would it take you to name it? And once you named it, what would you be willing to do about it? I'm still working out the answer, but I know now that buying the recorder was the first time in 2 years that I had done something entirely for myself, and I think my mother would have found that, if not exactly funny, at least satisfying. There's something I've been sitting with since the settlement was finalized, and I keep coming back to it not because it feels good, but because it feels true. What happened with Colt wasn't sudden. It didn't arrive in one dramatic moment I could point to and say, that's when it turned. It accumulated. The unreturned calls during my mother's treatment. The visits that ended before anything difficult had to be said. The way the word sacrifice kept appearing in his sentences, always applied to me, always framed as a problem he was generously offering to solve. He wasn't cruel in the way people imagine cruelty. He was strategic in the way people are when they've decided that the rules of fairness apply to everyone except the moment they become inconvenient. I think about Yvette a lot. She called me when she didn't have to. She had been with my mother's firm for 14 years, and she could have quietly updated her resume and let the whole thing dissolve. Instead, she picked up the phone. That's the thing nobody talks about when they tell stories like this one. There's always a person who does the small, unglamorous thing that makes the difference. She didn't save me, but she gave me the information I needed at the moment I needed it, and that's not nothing. That's actually most of what holding something together looks like. My mother kept binders, 6 boxes of them, every invoice, every signed contract, every change order going back to the year she opened the business. I used to think that was just how she was built, meticulous to a degree that occasionally bordered on difficult. I understand it differently now. She was building something she intended to last, and she knew that things which are intended to last require documentation. She had also, it turns out, built protection into her trust language that she never told me about. I don't know if she anticipated Colt specifically. I think she understood people well enough to anticipate the type. What I want to say about the recorder is this. Buying it felt small at the time. It felt almost embarrassing, standing in the electronics aisle trying to look like I had a reason to be there. But it was the first decision in 2 years that I had made entirely from clarity rather than from exhaustion. That distinction matters more than I can fully explain. Most of the poor decisions I've made in my life, and I've made some, happened in the gap between what I actually thought and what I was too tired to argue for. Cole understood that gap. He had been widening it deliberately for months. The things we choose to document say something about what we believe is worth protecting. My mother believed the work was worth protecting. I believed the same. And I think the honest version of any life, the version that holds up under scrutiny, is the one where you did the painstaking thing when it would have been easier not to. Not for the outcome. Not for the story it makes afterward. But because some things are worth the effort of getting right, and you either know that about yourself or you don't. I'm still figuring out what comes next. The business is stable. The binders are in my office now. I have not spoken to my brother since the papers were signed, and I don't have a plan to. That might change. It might not. What I know is that I am no longer managing the weight of his choices on top of my own, and that particular form of likeness is something I didn't know I was missing until I had it back.